Swayam Prabha. Digital India. Educated India.
Hello, my name is Professor Dr. Avinash Dadij. I am the Dean of Institute of Legal Studies and Research, GLA University, Mathura. Dear students, today we are going to talk about a topic which is very important for any business purpose. Business is all about making good agreements, because when you sell things, you buy things, you produce things, you make a lot of agreements with so many people. Like you make agreements with your supplier, you make agreement with distributor, with your vendor, with the people who are giving you different types of services, and as well as to your consumer. Okay. So when you are making agreements, then obviously you have to be very careful, because whatever you write in that agreement and you agree on that agreement, that becomes the law on you. Okay. So there is a law of contract, no doubt, there is a law which defines the boundaries, but within the boundaries whatever you write, so contract is your personal law, okay, created by two parties. So you need to understand that how to make good agreements, when agreement is made, what are the legal requirements to make an agreement, and then we will talk about the Sales of Good Act also. Okay. So let us start. Introduction of Contract Act 1872. According to section 2H of the Indian Contract Act 1872, an agreement enforceable by law is a contract. Okay. An agreement enforceable by law is a contract. Very simple definition. So let us try to understand what is the agreement, what is the enforceability of the law, and then finally what is the contract. And contract is a combination of two elements. There must be an agreement between two parties, okay, and agreement must be enforceable by law. It means there should be some obligation. So let us define what is agreement. According to section 2E, every promise or set of promise forming consideration for each other, that is the agreement. And promise, what is the promise? According to section 2B, when a person made a proposal to another to whom proposal is made, if proposal is assented thereto. So these are very simple definitions, but you need to understand they have some very deep meanings. If you understand them, then I think that will be easy for you to understand that what is not a contract. So an agreement is basically when you are promising someone to do something for a consideration. So the word consideration is very important here. Suppose you make a promise to your friend that tomorrow I will come to your home for dinner, or you come to my home for dinner, and then tomorrow morning, tomorrow evening you say no, I do not want to do it. Then is it possible that your friend can go to the court and ask you to fulfill your promise, and saying that he has made an agreement with me that okay, that we will do it, but no, because there is no consideration. Consideration means financial part. There has to be some money involved in it. Okay. So if I say that okay, tomorrow I will come to your home cooking your dinner, okay, and then you say okay, if you do this, I will pay you 50 rupees. So that is a consideration, that is an agreement. So if you ask me, suppose Professor, can you come to my home and cook my dinner? I said okay, I can come and I will charge 50 rupees. So then it becomes an agreement. Okay. And tomorrow if you break your promise, then I can go to the court and say that please ask him to fulfill his promise. Promise means give me my money, because I was ready to do my job, but he declined. In the same manner, when I say enforceable by law, so now I believe you understand the concept of agreement. There has to be some financial part involved in this thing, and that the financial part should be considerable for the both parties. Okay. So, suppose like if I just say you, okay, please promise me that you will give me 20 rupees tomorrow, and I say okay, but if I do not give you, then that is not an agreement, because then the financial part is not only from the one side. What I am giving you from my side, nothing. So, when both parties are giving something to each other, one party is giving product or service, another party is giving some type of financial arrangement. So, then that will become the agreement. Second question is enforceable by law. Suppose if I say that ask you to do something illegal work, I say okay, I will give you 100 rupees, you go and steal that car. Like if I ask you, okay, I will give you 1 lakh rupees, you go and steal that car, and then if you do not do it, can I go to the court and say, okay, we have made an agreement, because I asked you to do something and I was giving you that money, but you failed. So, in that scenario, the condition of agreement fulfills. However, that agreement is not legal, that agreement is not enforceable by law. You cannot enforce the thief agreement in the courtroom. So, what is not allowed as the law in the law, that cannot be the subject matter of contract law. So, we will see more in details, but just to try to understand that the basic understanding. Then offer. According to section 2A, when a person made a proposal, when he signifies to another his willingness to do or to abstain from doing something. So, agreement is offer plus acceptance. So, offer, when you say that you do it or you do not do it. So, when I am offering you something, when I am asking you to do something or not do something, suppose if I say, okay, if you do not break this car, like okay, breaking the car is again illegal thing, but if I say, okay, if you do not do it, then I will pay you this money. So, even money can be paid for not doing something. Okay, like for example, if I say that if you do this business, I will give you money. If you do not do this business in this city, like okay, you are running a very good business in a city, and the another company comes and say, okay, we want to start our business. You say, why are you doing it? I will give you 10% of my profit if you do not come to this city for your business. Okay, so then I am giving you that money for not doing something. Okay, so agreement means offer plus acceptance. If the opposite party accepts the offer, then only it becomes the agreement. If you offer but the opposite party does not accept your offer, then that will not be the agreement. Consensus ad idem. According to section 13, meetings of mind or identity of mind or receiving the same thing in the same sense at the same time. All contracts are agreement, but all agreements are not contract. That is very important. All contracts are agreement, like a contract cannot be formed without the agreement, but not necessary that all agreements are contract. Like suppose if you make a friendship agreement with someone, that is not a contract, because when I say contract, it means that it should be enforceable by law. Okay, your friendship agreements are not enforceable by law. Okay, so please try to understand agreements and contracts are not the same thing. All agreements are contract, but all contracts are not agreement. So, contract in a easy language, now we can understand contract is agreement plus enforceability before the law. Okay. So, first there has to be some agreement and finally there should be enforceability by the law. So, essential element of a valid contract. Section 10. First, offer and acceptance. Second, intention to create a legal relationship. Third, consensus ad idem. Fourth, consideration. Fifth, capacity to contract, whether, see, suppose you make an agreement, you make a contract with a minor or with a the person who is not capable to make the agreement or contract, maybe some lunatic person, okay, some mad person. If you make a contract with him, he does not have the capacity. If you make a contract with a minor, like suppose a minor, a kid is 10 years old, 12 years old, and you make a contract with him without his parents' approval or a written approval, then that is also not a contract. Free consent, that consent of the opposite party should be free, okay, because if you threaten someone, if you do a fraud with someone, and then if you are receiving someone's consent, that is not a valid consent. Legality of the object, whatever the object, like the the consideration, the object of the consideration should be legal. You cannot make contract for illegal objects, like narcotics, drugs, alcohol, all these things which are illegal in nature. Okay, like alcohol is legal in some states, but in some states, suppose the alcohol is not legal, like the Gujarat and Bihar right now, they don't have a legal status for the alcohol. So, if you are making a contract about selling and buying alcohol in those states, so that does not fall the legality of the object criteria. And possibility of performance, there has to be some possibility of performance. If you make a contract with someone that is absolutely impossible by the nature or by the legal side, then that is also not valid contract. And writing and registration. So, contract can be verbal also, but it is always good that you make your agreement, a contract in writing, and if possible you register also your contract. Types of contracts: absolute contract, contingent contract, express contract and implied contract. We will go one by one. So, even contracts are also different types of. So, one need to understand under which category my contract is falling. Valid contract. If all the conditions are fulfilled, it is called a valid contract. Contingent contract. In a contract to do or not to do something if an event is collateral, does or does not happen. So, that is basically subject to something, like if I say tomorrow I can give you this product subject to rain does not come, because in the rainy season you can't supply your product. Okay. Suppose you are selling a product which is not possible in a particular geography situation or in anything. So, in like suppose nowadays lockdown is happening in corona. So, maybe you can make a contract that after 1 month I will supply you this product provided the complete lockdown does not happen. So, if the complete lockdown happens, then obviously you can't do it. So, that is a contingent contract. Express contract, when contracts are either in writing or in oral. So, suppose you are not making agreements in writing, but you are just expressing your offer, he is expressing his acceptance. So, most of the time in business world, not in the corporate, typical corporate, but in the small businesses, contracts are made by express contract. Implied contracts, when contracts are neither in writing nor in oral, like we believe that contract is there, but it has not been in any form, oral or writing. Absolute contract, a contract which is not dependent on the fulfillment of any condition, like if there is no condition involved, then that will be considered as a absolute contract. Invalid contracts. Void contracts is void ab initio. Void means from the beginning it is illegal, it does not exist. Voidable contract, a contract which is valid until unless avoided by either the party. Okay. Illegal contract, an agreement forbiddable by the law. Unforceable contract, it is a valid, but due to some technical defect the contract becomes void. In that case, defects are removed, the contract is enforceable, lack of the registration, lack of the signature and all these things. So, you need to understand there are four types of criteria of contract. One is void. So, if you make an agreement, a contract which is illegal in nature, okay, so that contract is void ab initio, from the beginning that it is illegal, nobody, no party has any right to enforce that contract. Okay. Some contracts are voidable, a contract which is valid until unless avoided by the other party. You make something, maybe that is not illegal, but not accepted by the law, but it does not say that it will be illegal until and unless one party decides to disobey that contract. Okay. Other types of contract, executed contract. In a contract where both the parties have performed their obligation, there is a remaining nothing to perform. So, if all the performances of the parties have been executed, that will be called executed contract. Executory contract, in a contract where both parties are yet to perform their obligation. Unilateral contract. In a contract, one party has performed its obligation and other person is yet to perform his obligation. Bilateral contract. In a contract where both the parties have performed their obligation, bilateral and executory are the same and interchangeable. Offer. According to section 2A, when a person made a proposal, when he signifies to another his willingness to do or abstain from doing something. When you are giving the offer, you are making it very clear that you want to do something or you don't want to do something. Okay. So, abstain from doing something is also an action. You say that I will not do it, I will not do this business, or I will not break this thing. So, that is also a type of offer to the opposite party. Types of offer. Express offer. When offer is given to another person either in writing or in oral. Implied offer. When offer is given to another person neither in writing nor the oral. Specific offer. When offer is given to a specific person, it is not an offer like general offer. The next one, you are not saying that this offer is available to everyone. You are making very specific offer that my offer is available to only those companies who are having more than 100 crore rupees turnover. So, any company which is having less than 100 crore turnover, they cannot respond to you. General offer. When offer is given to entire world at a large, like you say, okay, I am looking for something to do and I am giving my general offer to everyone. Cross offer. When both the person are making identical offers to each other in ignorance of others' offer. Okay. Cross offer, that is a cross offer. Counter offer is when both the person are making offers to each other which are not identical in ignorance of others' offer. Then finally, the standing offer, an offer which remains continuously enforceable for a certain period of time. Okay, you make an offer that for the next 6 months I am ready to buy this product at this price. So, that is a standing offer. Anybody can come and fulfill the conditions of my standing offer and my offer will be accepted. Legal rules for offer. Offer must be given with the intention to create a legal responsibility. That is very important. If your intention is not to create a legal relationship, you just want to give an offer for some scientific experiment or some other things, that is not offer. Offer must be definite. You cannot make a vague offer. You have to be very, very specific in your offer. There is a clear-cut difference between offer, invitation to offer, invitation to sell. Offer must be communicated. If you do not communicate your offer, you just believe that the other party must have accepted without communication, that is not the offer. Mere statement of price is not an offer. This is very important. Like suppose if someone comes to you, say, okay, what is the price of this product, and you say, yeah, 100 rupees. That does not mean that you want to sell it. Okay. The other party cannot say that, okay, you told me the price of this house, then it means that you want to sell. Suppose if someone is coming to your home or your property and say, okay, what is the price of your land, and you say it's like 50 lakh rupees. That is not the implied offer. The offer has to be very specific. Then you should, if you say, okay, the 50 lakh rupees and I am ready to sell this property to you at the rate of 45 lakh rupees. So, that is the implied offer. That's a very definite offer. The offer has been communicated. Then only if the other party accepts, okay, again it does not become the legal responsibility of the opposite party to buy your land at that price, because that is only the offer. Once the opposite party accepts your offer, okay, then only it becomes a contract, an agreement, and which is enforceable by law. Let us talk about acceptance. According to section 2b, when a person made a proposal to another to whom proposal is made, if proposal is assented thereto, it is called acceptance. If you do not accept the offer, you just hear the offer and you move away, then there is no acceptance, and your silence cannot be considered as a acceptance. Acceptance must be given as per the mode prescribed by the offerer. So, the offerer says that if I am giving my offer, the acceptance must come in writing, though then it must be in writing. If you are giving an oral acceptance, then that will not be considered as acceptance. Acceptance must be given before the lapse of time or within reasonable time. If I say that my this 45 lakh rupees offer stands valid only for 3 days, and if you don't reply to me in within the 3 days, on the 4th day you cannot come and accept my offer, because my offer has been lapsed. Acceptance must be unconditional. So if you make a counter offer and you say, okay, yeah, I am ready to buy your house, however, if you reduce your price by 5 lakh rupees, like I am ready to pay you only 40 lakhs. So in that scenario, that is not acceptance, that is more like a counter offer. Okay. So then that will not be considered as an acceptance. Acceptance may be given by any person in case of general offer. If the offer is very general, like you are not making any specific offer to anyone, in that scenario you can anyone can come and accept your offer. Acceptance must be communicated. If you don't accept your communication, the same thing as the offer, you cannot go and say, okay, yeah, I heard your offer and I was interested and I was ready to buy, but then you sold your property to someone else. That is a breach of contract. No, you can't do it, because you have to go and communicate your acceptance to me so that I can understand that yes, you are interested, then only it becomes the contract. Mental acceptance is not acceptance, or acceptance must not be derived from silence. That is very important. Sometimes people, suppose you are going again and again to that person's property, you are giving very good indications, but you are not giving any acceptance, unconditional acceptance. And if I believe that your silence, sometimes we believe that silence is the acceptance. No, as per the law, silence cannot be considered as a acceptance. Acceptance must not be precedent to offer. Like if you give a counter offer, then that is not the acceptance. Now let us talk about the consideration, because as I told you earlier, without consideration no agreement can turn into a contract. Okay, an agreement can exist between friends, between family, but if you want to make it as a contract, because when I say when it becomes a contract, it means that if any party breaches that contract, the opposite party can go to the court and ask the opposite party either to do their duty and fulfill the obligations out of the contract, or pay the damages. But in the absence of consideration, no agreement can be termed as a contract. According to section 2D, consideration is defined as when at the desire of the promisers or promisee or any other person has done or abstained from doing or does or abstain from doing or promises to do or abstain from doing something, such an act or abstinence or promise is called a consideration for the promise. So if you do something, okay, if you do something in the expectation of getting something, that is only considered as a consideration. When a party to an agreement promises to do something, he must get something in return. This something is defined as consideration. Okay. So legal rules for consideration, it must move at the desire of the promiser. Okay. If someone is giving the accepting the offer, he must have some consideration in his mind. It may move by the promisee. It must be past, present and future consideration. It is not necessary that we are talking about future consideration. If I say, okay, if you do it, then whatever money I like you have taken maybe 2 lakh rupees loan from me, so that loan will be waived off. So that is a past consideration. Now in future or present or in future, you are not getting anything, but it can be past, present or future consideration. It need not be educate and it must be real. Not necessary that it should be sufficient. Like suppose if I say that I am suppose you say that I want to buy your land for 10 lakh rupees. Maybe the real price of the land is 45 lakh rupees. Okay. But if the landowner is ready to sell that property at 10 lakh rupees, that will be enough for the consideration. The party cannot claim that, okay, no, it was not sufficient. Sufficiency depends on the will of the parties. Okay. and it must be real. You cannot give an imaginary consideration, you cannot give, okay, I will give you X, Y, Z, which doesn't exist in the market. Like, so suppose if someone says that after death you will go to heaven, okay, that is my consideration. No, that cannot be accepted. It must not be illegal, immoral or opposed to public policy. If you give some immoral or illegal or opposed to public policy considerations, then that consideration cannot be accepted. Stranger to contract. It is general rule of contract that only parties to contract can sue and be sued on that contract. This is known as doctrine of privity, relationship between all parties to contract. Okay. So, what we believe that who can file the case against whom? We cannot allow any third party which is not known to the contract file case against each other under the contract law. However, there are some exceptions. A trust or a charge, if there is a trust is created, if there is someone who is the legally in charge of something, that person is maybe not direct party of that contract. However, on the behalf of the trust or the charge, they can file the case. Marriage settlements, partition or other family arrangements, estoppel, assignment of contract, contract with agent, convenient running with the land. So, these are the exceptions where the third parties, maybe not the party of that contract, can also file the case against. Contract without consideration is void. Exceptions like love and like for example, love and affection, compensation for voluntary service, promise to pay at a time, completed gift, agency, charity, contract to bailment, no consideration, no account. So, this is very clear. Now, we will talk about the capacity to contract, that is very important. When I say capacity to contract, following are the conditions for a person to enter into a contract. First, he must be major. Major means he must be adult, like more than 18 years old. Then only he can enter into contract by himself, or he can do it by with the help of his parents or guardian. Second, he must be sound mind, like he must not be a lunatic person. He must not be, it's not about stupidity. A stupid person can make the agreement or contract. Lunatic, mad people, the people who doesn't have sound mind, maybe due to some medical health or some other issues, if they are facing some mental issues and as per the medical records, those people are not having sound mind. When I say sound mind is they are not capable to understand the consequences or the nitty-gritties of that contract or that agreement, that they are not they don't have capacity to make a contract. And he must not be disqualified by any other law. So, if the law says that suppose you are the defaulter and law says that in next 1 year this person cannot do any business in this market. For example, in SEBI they do it, in the SEBI if someone is doing insider trading, in that scenario SEBI can ask that for the next 2 years you will not do any trading in this market. So, in that scenario if that person is making a contract with anyone regarding the trading, that will fall under this category because he is not qualified to do trading by the law. So, he is not able to make any contract. Disqualified persons to enter into a contract: minor, unsound person, otherwise alien money, insolvent, convict, company, corporations. So, these are the people, they are disqualified. Minor, because as you can see, a lot of business are happening through the minors also. We want to do business through our kids, we want to give them legal property, we want to create something good in their favor. So, how it happens? According to Indian Majority Act, section 3, minor is defined as any person under the age of 18 years. In the following cases, a person is said to be minor if he does not complete the age of 21. Any person under the Guardian and Wards Act 1890, any person which comes under superintendence of the law or legal representative. So, if someone is falling under these two categories, he will be considered major only at the age of 21, otherwise at the age of 18 a person becomes major. Rules governing minor agreement. An agreement with minor is void ab initio. If you make any agreement with a minor, okay, without fulfilling the other conditions, that agreement is a void ab initio. Okay. So, that agreement does not have any legal value. Minor cannot be a promisee, minor cannot ratify his agreement on attaining the age of majority. Okay. So, it is not like that first to make an agreement with a minor, and once he becomes major, then he can say, okay, now I want to change the agreement, okay, or I want to do the agreement. Unsound person. So, in minor situation they can make an agreement with the help of their parents or their guardian, okay, because those are the people who are legally responsible for that minor. Unsound person. According to section 12, a person generally sound, occasionally unsound, can enter into a contract when he is a sound mind. So, this unsoundness sometimes is permanent, sometimes it is very temporary. So, in that scenario, if someone is not sound at the time of the making the contract, then only he will be barred from making such type of contract. So, like suppose someone is unsound during some period of the time, maybe from I suppose like July 2021 to October 2021, he was under some medical supervision, but in October 2021 the doctor declares that now he is good, he is a sound mind person. So, in December if he makes the contract, so then that person is capable to make the contract. Okay. So, we need to see at what moment he is making the contract, and if that moment he is having the sound mind, then law does not prohibit it. A person generally unsound, occasionally sound, can enter to when he is a sound mind. Person of unsound mind are lunatics, idiots, drunken or intoxicated persons. Okay. So, even someone is drunk, you know, it is not about the unsound mind that is only like the lunatics, but if someone is drunken, completely drunk or intoxicated, drugged, in that moment he or she is not capable to understand the nitty-gritties, consequences or considerations and all these things relating to a contract. So, at that moment if someone is making the contract, that contract will be void. So, suppose if you make an agreement contract with someone who is intoxicated completely at that moment, he is not understanding what he is doing, and if you get his signature on a contract, that and next morning if he wants to cancel that contract, he can do, because if he can prove that previous night he was intoxicated, and obviously it is a matter of medical evidences whether on that particular day he was intoxicated or not. Contract based on free consent. As I said that the consent is very important, because the both parties are making their own rules and regulations regarding their businesses. So, the consent must be very free. Section 13 of the Indian Contract Act 1872 defined consent. It means when two or more persons are said to consent when they agree upon the same thing in the same sense. Section 14 of Indian Contract Act defined free consent. It means consent is said to be free when it is not caused by coercion or as defined in the section 15, under influence as defined in under 16, fraud as defined in section 17, misrepresentation as defined in section 18, mistake subject to the provisions of section 20, 21, 22. Consent is said to be caused when it would not have been given but for the existence of sub-coercion, under influence, fraud, misrepresentation or mistake. Okay. So, you need to understand that consent can be not free also. Suppose like if I say about the under influence, suppose if a boss is asking a junior guy that to sign the contract, and it is very clear that he is the under influence of that person, okay, and then the person can claim that my consent was not free, though I gave my consent, but I was under the influence of that person. And when I say under influence, means like I was under the threat that if I do not sign this agreement or contract on his behalf, I may lose my job also. Okay. Fraud can also be there. If someone is giving you false promises and then you are believing on the false promises and signing the contract, that can be a fraud. Misrepresentation, you believe that the other person is saying that he is Mr. X, but in reality he is the Mr. Y. So, if he is misrepresenting himself, if he is misrepresenting the facts, then that can also be a case of not free consent. Key clauses found in the contract. When I say that when you make an agreement, okay, or the contract, as a business person you need to read few very important clauses. The first is confidentiality. When two or more firms enter into a contract, there will be no doubt be a significant exchange of information in order for both sides to perform their contractually stipulated obligations. In light of the need to furnish certain information about each other's financials and business practices, it is imperative for the contract to contain a strongly worded confidentiality clause. This clause should preclude both parties from divulging any other information shared during the course of the transaction. So, suppose now you are doing business with someone, then you are sharing lot of confidential business information with each other, okay. And obviously when you want to win the contract, the other party also asks lot of confidential and sensitive information from your side, and you also provide. So, it is a long term association and you are sharing lot of financial data, information. So, whatever the parties are getting that information during the contract, that must be protected by the confidentiality clause. Otherwise, in future that opposite party can misuse that data, okay. So, if you want to protect the sensitive commercial market data of your company, then you should read confidentiality clause very carefully. Force majeure, this is very important. This phrase force majeure literally translates to the greater force, like the act of God. This clause should also be included in the commercial contract, as it can protect parties from circumstances that arise or beyond anyone's control. Like for example, currently this lockdown happened. So, if you have made an contract with someone that, okay, like suppose I am talking about March 2020. So, suppose you have made a contract with someone that in April 10th I will supply you like 10 ton of this particular product, but then government introduced the lockdown, nobody was moving from one place to another place. In that scenario, that situation is beyond your control. So, the opposite party cannot force you to fulfill your contractual obligations because of the force majeure clause. Suppose war happens, some earthquake, some natural disaster, these type of activities which are not anyone's control. So, you should also understand the force majeure clause because it protects the both parties. Termination triggers. In a business, things often do not occur as planned, and thus parties must be able to cut and run as necessary. This section of the contract must clearly lay out the circumstances under which one or both parties may terminate the contract irrespective of the time left under the agreement. See, contracts are just like gentlemen's understanding. See, like frankly speaking, some people say that people make the contract so that they can break them, but that is not the objective of any commercial contract. In the commercial contract, both parties try to make the certainty in their business. Like suppose if I tell you that I need 5 ton of your product every month, like the raw material every month in my factory, so that I can go with my production. So, if I make a contract with you for suppose 24 months at a fixed price, then I am very certain that for next 24 months I will get my raw material, okay. And in the return I give you promise that I will give you suppose 10 lakh rupees per month for your product. So, in that scenario both parties are convinced that what they are going to get every month for next 24 months. So, that certainty is very important in business. However, the business are absolutely uncertain due to some reasons, business reason, financial reasons, and some any other reasons. Suppose you are not able to supply me raw material, okay. In that scenario I must have right and I must put some termination triggers clause in my agreement that if you do not supply the required material for next suppose 2 or 3 months, then I must be able to exit from the contract. Okay, then you cannot say no, why you are exiting from this contract, you are breaking the contract. or if I am not able to give you that money for next 24 months, like suppose after 3 months if I stop my payments, then there has to be some clause in the agreement that if you do not pay more than 2 months, then the contract can be terminated from my side, and obviously you will pay your amount, but you do not want uncertainty, you do not want confusion in your business. So, that is why termination clause is very important. And then within the termination clause, sometimes it is very important to mention the timing also, that when you are terminating the contract, you have to give a reasonable notice period to the opposite party. That is another interesting point, jurisdiction. When the parties to a contract are located in more than one state or perhaps more than the one country, it may not be clear which state's law govern the arrangement. Therefore, commercial contract should always specify the state the law will have jurisdictions over the agreement, so that it is perfectly clear which laws are applicable. Suppose laws are different in Gujarat, laws are different in Tamil Nadu, and both parties are making an agreement. So, they need to be very careful that which law will apply, where the case will be filed, whether it will be filed in Gujarat or in Tamil Nadu. So, because see, it looks good that we will not go for fight, but in case if you go for fight, you need to understand, suppose you are working for a company in Gujarat and the contract says that the jurisdiction will be in Tamil Nadu. So, you need to understand now you have to go to Tamil Nadu, face the case, and the laws will be very, very different. Okay. And for the international contract, this can be the case of different countries like the French and Indian. If they make a jurisdiction, that the jurisdiction will be the of the Paris court, and the law applicable will be the French law. As per the contract law, this is very much possible because you can choose your law, you can choose your jurisdiction. It is not automatic. It is not automatic. Like in other civil laws, rules are very defined that if you are situated in this area, the local court will apply. In contract law, you can choose your law, you can choose your courts also. Dispute resolution. Even the most well drafted contracts are go for the conflict. As a result, it is for the utmost importance to clarify the parties' plan for the dispute resolution in the event that is issue arises. So, you need to understand, maybe you do not want to go for litigation. So, first you say we will go for the mediation, then we will go for arbitration, and if the arbitration fails, then only we will go for the civil litigation. So, this dispute mechanism you should also understand very properly. Damages. In the light of the frequency of the contract breaches and in an effort to deter them, it is also standard practice for commercial contracts to contain clauses related to damages. In general, liquidated damages will be included, which is usually a predetermined amount that will be owned if one side fails to perform. So, like suppose if you fail to give me 10 ton raw material every month, then I can put a clause in damages that if you fail to do it for the first month, you will be paying 10% of the penalty, and if you do it for next month, then you will be paying 20 months. So, you can fix the damages even in your contract. So, if something goes wrong by any party, then the legal obligations are well settled even in your contract. Now, let us talk about the Sales of Goods Act 1930. Originally, the transactions related to sales and purchase of goods was regulated by Indian Contract Act 1872. A separate act, the Indian Sales of Goods Act, came into force in 1930. The word Indian was removed in 1936. Applicability of this law is whole of India. Scope of Sale of Goods Act. This is applicable only on movable goods. It is not on the immovable property. Movable and movable means like house is a immovable property, but a car is a movable property. A contract of a goods is a contract whereby the seller transfers or agree to transfer the property in goods to the buyer for a price. The term contract for sale is a generic term and includes both a sale of an agreement to sell. Basic of like comparison, meaning sell. When in a contract of sale, the exchange of goods for money consideration takes place immediately. An agreement to sell, when a contract of sale, the parties to contract agrees to exchange the goods for a price at a future specified date. Like suppose you make an agreement to sell that okay, I will sell you this house, I am currently giving you I am receiving only 10% of the amount and 90% of the amount you will pay me after 3 months. That is an agreement to sell. Nature, it is absolute sell, an agreement to sell is conditional. You really do not know whether you will get 90% money or not within the period. Types of contract, executed contract and executory contract. In future someone will execute the contract. Right to sell is buyer, here is seller. Transfer of risk to the buyer remains with the seller, because once you sell the property and if you do not get your money in 90 days, then you are owning the risk. Title is transferred to buyer, title is remained with the seller. Okay. In the sale you transfer your title also, you transfer your legal rights, but here titles are not transferred until and unless the opposite party fulfills the remaining obligations. Formalities of contract of sale, offer and acceptance, the same thing. Okay. Delivery and payments. It is not necessary that the payment for the goods to the seller and delivery to the buyer must be simultaneous. There can be made at different times or in installments as per the contract. So, in movable goods, when I say a car, when you are buying a car on EMI, okay, so you are not giving money on the same date, but you are promising that every month for next 60 months I will pay you X amount of money. So, till you complete your transaction, you do not become the owner of the car. The ownership remains with the bank or the financial institutions, but you can use that car. Okay. Express or implied, the contract can be in writing, oral or implied, it can also be partly oral or partly written. Definition of goods, the Act defines the goods in section 2(7), any movable property except actionable claims and money. Okay. So, it is not about the claims or money, stocks and shares, they can also move from one place to another place, they are not fixed to any property, but they do not come under the Sales of Goods Act. The growing crops, standing timbered grass, the thing that are attached of forming part of land which is agreed to be severed from the land before the sale. So, the growing crops, obviously they are attached to land, but we know that ultimately they will be cut and they are movable goods, they fall under the definition of goods. Types of good, existing goods like the specific goods, ascertained goods or unascertained goods, future goods, contingent goods. Okay. So, let us see existing goods. Existing good means the goods which are either owned or possessed by the seller at the time of contract of the sale. Specified goods, these are the goods, these are identified and agreed upon the time when a contract for sale is made, for example, TV, VCR, car and all these things. Ascertained goods, goods are said to be ascertained when out of the mass of unascertained goods, the quantity extracted for is identified and set aside for a given contract. Thus, when part of the goods lying in the bulk as identified and embarked for sale, such as goods are terminated as ascertained goods like the crops. Unascertained goods, these are goods which are not identified and agreed upon at the time when a contract for the sale is made, like goods in the stock or lying in lots. Suppose some goods are lying in the godown, so you do not know how much is there, even you can't see it from at the time of making the contract, but you believe that goods are there. Okay. Future goods, section 2(6) of the Act, future goods have been defined as the goods that will either be manufactured or produced or acquired by the seller at the time the contract of sale is made. The contract for the sale of future goods will never have the actual sale in it, it will always be agreement to sell. You understand? So, suppose if I say that I will give you a 10 ton of movable goods like the raw material after 6 months. So, at that moment I am not transferring any movable good, but I am just making agreement to sell that after 6 months you will get it. Contingent goods, these are the goods the acquisition to which by the seller shall depends and on the contingency which may or may not happen. Like for example, agriculture crops, if I say okay, this is my land, this is my crop and after 3 months I will sell you my mustard or maybe any other product, agriculture product. You really do not know what will happen during the 3 months. If a natural disaster happens, you may lose your entire crops. Okay. In that scenario, that is a contingent goods, you really do not know whether you will get it or not. 5 essential feature of contract of sale: two parties, subject matter to be goods, transfer of ownership of goods, consideration is price, contract of sale may be absolute or conditional, essential elements of a valid contract. So, contract law deals with the movable as well as the immovable goods, but here when you are dealing with movable goods, then sales of good act will apply. When you are talking about immovable goods, then transfer of property act will apply, TPA will apply. So, contract is an umbrella law, and then we have separate laws for movable goods and immovable goods. Doctrine of Caveat emptor. The doctrine of Caveat emptor is an integral part of the Sales of Goods Act. It translates to the let the buyer beware. This means it lays the responsibility of their choice on the buyer themselves. It is specifically defined in section 16 of the Act. There is no implied warranty or conditions as to quality or the fitness of any particular purpose of the goods supplied under such a contract of sale. However, the buyer can shift the responsibility to the seller in the 3 following conditions. Okay. So, when you are buying a movable goods, the buyer has to take the complete responsibility. And whatever happens wrong with that particular good, suppose you go to buy a car. Okay, I just show you my car. Okay, this is my car, you want to buy, the price is 2 lakh. Then now it is your responsibility to check whether my car is good or not. I will tell you, yeah, my car is good, at best of my knowledge my car is good. Okay. But now it is your responsibility to go and check whether my car is good or not. So, in future if something goes wrong with my car, you cannot blame me, because this responsibility goes to you. However, you can shift this responsibility to me if the buyer shares with the seller his purpose for the purchase, the buyer relies on the knowledge and technical expertise of the seller, and the seller sells such good. So, suppose in this scenario, if I am the mechanic, okay, I am the mechanic, I am taking the full I am claiming in my advertisement that my cars are good, I have checked all the parts of the car, like in second hand cars, some companies are buying the second hand cars. So, they are taking the full responsibility that we have checked these cars thoroughly, there is nothing wrong in the car, cars are in the fit shape. So, basically as a buyer you are relying on the technical knowledge and expertise of the seller. In that scenario, if something goes wrong, then you can blame the seller. But as a layman, suppose if I say, okay, I am not expert in car, I am just a layman, I believe that this car is running very well because I am driving, but I really do not know what is wrong in the car inside, maybe there is some problem which I am not able to understand, or maybe there are some problems which will occur after few months, in that scenario you cannot blame the seller. Exception to the doctrine of caveat: fitness of the product for the buyer's purpose, goods purchased under the brand name, goods sold by description, goods of mercantile quality, sale by sample, uses of trade, fraud or misrepresentation by the seller. So, these are the standard exceptions. So, my dear students, what I was trying to explain you through 2 laws, contract laws and Sales of Goods Act. So, in the contract law they talk about generic idea of contract. Okay. So, there are few things to understand very clearly. First, contract is the law of the parties. Okay. When 2 parties wants to trade something, then they create their own rules, regulations and the entire ecosystem. It is a free will of the parties. Okay. There is no one who is forcing them to make a contract. If there is any force, any fraud, any threat, any misrepresentation, that contract is not valid, that contract will be voidable. Okay. You understand voidable here, that if I say that at that moment I was under force, I was under threat, that is why I signed the contract, but now after 2 months I want to withdraw from this contract because now I want to exercise my legal right, and you go to the court and say that this guy threatened me, that is why I signed this contract, then it will become the voidable contract. Okay. And second condition, whenever you are making the contract with someone, you need to check whether the opposite party is capable to contract or not, like the minors, lunatics, idiots and the people who are intoxicated, they are not capable to sign a contract. Okay. So, whenever, or some people who are not allowed by the law to sign the contract. Okay. So, like for example, in a companies they have given special power to some very senior officers only to sign the contract. So, if a junior person is signing the contract, the company will not be responsible. Okay. So, you need to understand very carefully that contract is very important for businesses, and if you understand the important clauses in the contract, one thing, because you are doing only business, you do not want to understand the too much legal side, but if you go deep dive to those agreement clauses, then you will understand that those clauses are directly affecting your business decisions. Like for example, as I mentioned, jurisdiction. So, in the jurisdiction, if I say that the matter, if something goes wrong, you have to go and file the case in, suppose, outside of India or in other state, then obviously you do not want to do it. Okay. So, you need to understand the nitty-gritties of the contract, how a contract is made, what is the offer, what is the acceptance, what is the consideration, capacity to make a contract, and finally the agreement clauses. The second part, sales of good act. In some businesses where you are dealing with movable property, then how agreements are made, and what is the difference between agreement to sell and agreement. Okay, when there is an agreement to sell, it is like a future promise that you will do something or you will not do something. So, you have to make a difference between agreement to sell and agreement under the Sales of Good Act. So, I hope this lecture has given you enough understanding what is the contract law, why contract law is important for your business, and believe me, most of these clauses are very common. You will see those clauses again and again in all types of contract. So, once you try to understand those clauses through your legal team, you can go and talk to your law professor or you can talk to your legal manager and tell him that I want to understand these clauses. They are written in a very legalistic language. So, please explain me in simple English and tell me how these clauses can hurt me in my business or how I can use these clauses for my business strategies and decisions. If you are able to do it, the contract law will act in your favor. Thank you very much.